2018, Officer Courtney Brown and Officer Christy Wilson of the Roswell Police Department pulled over Georgia resident Sarah Webb for allegedly speeding on her way to work in Duluth, Georgia. After Ms. Webb pulled over, Officer Brown approached the vehicle.
Stay in the car.
Sorry, my window doesn't hold.
Officer Brown, Roswell Police Department. You know how fast you were just going, ma'am?
I'm so sorry, I'm late for work.
So you could go over 80 miles per hour on 92? No, ma'am. You have your driver's license and your insurance card?
Yeah, my insurance.
Turn off the car and pass me the keys, please. The ground's wet. It's been raining. You're going over 80 miles an hour
so
on this type of a road. That's reckless driving, ma'am.
This is LexisNexis. I'm trying to look it up. I don't have it printed off.
Give me 1 second. I'll be right with you. Go for it.
A single coin, flipped in the front seat of a patrol car, off camera, decided whether an American citizen would spend the night in jail. That is not a metaphor. That is a documented fact, confirmed by body camera audio, official department statements, and a police chief's own public admission. On April 7th, 2018, in Roswell, Georgia, that coin came up heads. Picture it for a second. Not a judge, not a jury, not even a radar gun. A quarter, spinning end over end in the dark interior of a patrol vehicle, while a woman named Sarah Webb sat on the side of Georgia State Route 92, unaware that her fate was being decided by physics and chance instead of law. That image, a coin toss, standing in for due process.
My CAD's not working. Who's that?
A head, R tail.
Okay.
Off camera, Officer Wilson pulls up a coin flip app on her phone and states, quote, A head, R tail, meaning that if the coin lands on heads, then Ms. Webb should be arrested, but if the coin lands on tails, she should be released. Regardless of the result, Officer Brown would have been within her authority to arrest Ms. Webb under both Georgia law.
Here is what the record establishes. Sarah Webb was driving to work in Duluth, Georgia, on a rain-slicked road when Officer Courtney Brown and Officer Christy Wilson of the Roswell Police Department initiated a traffic stop.
And Officer Christy Wilson of the Roswell Police Department pulled over Georgia resident Sarah Webb for allegedly speeding on her way to work in Duluth, Georgia. After Ms. Webb pulled over, Officer Brown approached the vehicle.
Stay in the car.
Sorry, my window doesn't hold.
Officer Brown, Roswell Police Department. You know how fast you were just going, ma'am?
I'm so sorry, I'm late for work.
So you could go over 80 miles per hour on 92? No, ma'am. You have your driver's license and your insurance card? Raining. You're going over 80 miles an hour on this type of a road. That's reckless driving, ma'am.
This is LexisNexis. I'm trying to look it up. I don't have it printed off.
Give me 1 second. I'll be right with you. Go for it. Hey. She was going like almost 90 down 92. Oh, really? She flew past me. I had to get up to 90 to catch her.
Wow.
My CAD's not working. Is yours? Did you?
I checked.
Can you see if can you check the tag too? I'm gonna have to restart this and see what the deal is.
Make me skid around.
I'm gonna take her probably for reckless.
Okay.
She flew past me going probably 80, 85 on 92 in the wet road. She said she's running late for work. I had to get up to 90 to catch her.
Now, under Georgia law, that alone doesn't automatically invalidate the stop. Section 40-6-180 of the Georgia Code prohibits driving at a speed that isn't reasonable and prudent, given road conditions, and Section 40-6-181 sets fixed numerical limits. Georgia courts have repeatedly allowed convictions based purely on an officer's visual estimate. In the 1992 case Brown v. State, the Georgia Court of Appeals held that an officer's testimony about visually estimating a defendant's speed was legally sufficient to sustain a conviction, the credibility of that estimate being a question for the jury, not a bar to prosecution. Stone v. State reaffirmed the same principle in 2002. So on paper, Officer Brown's testimony that Webb was traveling somewhere near 90 miles an hour on wet pavement could theoretically support both a speeding charge and, under Frazier v. State from 2003, a reckless driving charge under Section 40-6-390, which criminalizes driving in reckless disregard for the safety of persons or property.
Accurate measurement of Ms. Webb's speed. While the law varies between states, in Georgia, individuals can be convicted of speeding or reckless driving based purely on an officer's visual estimate of their speed. Georgia's speeding laws are found in Section 40-6-180 of the Georgia Code, which reads that, quote, "No person shall drive a vehicle at a speed greater than is reasonable and prudent under the conditions, and having regard for the actual and potential hazards then existing." And Section 40-6-181, which states that no person shall drive a vehicle at a speed in excess of certain maximum limits. In the 1992 case of Brown v. State, the Court of Appeals of Georgia determined that an officer's testimony of his visual estimate of the defendant's speed was legally sufficient to support a speeding conviction, holding that, quote, "Opinion testimony of an eyewitness may be used to establish speed, its credibility being for the jury to determine, and such evidence is sufficient to authorize a jury to conclude that the speeding laws have been violated." Similarly, in the 2002 case of Stone v. State, the Court of Appeals upheld a conviction based solely on the visual estimate of speed made by an officer because, quote, "An officer's estimate of speed is sufficient to support a conviction on a speeding violation."
The allegation was speeding, later escalated to reckless driving. That's the law. Here's where the story stops being about speed enforcement and starts being about something else entirely. Officer Brown's patrol computer wasn't working. She couldn't run the plate, couldn't process paperwork the normal way. Twice, her radio and her mobile data terminal glitched out mid-stop. And somewhere in that gap, in that bureaucratic malfunction, a decision had to get made. Cite her or arrest her? Straightforward enough, except for one detail that Officer Brown herself admitted on camera. She was not using any speed detection device. No radar, no LiDAR, just a visual estimate made while she was also driving in the rain, trying to catch up to a vehicle she says was pulling away from her.
Evidentiary standard would apply to a reckless driving charge, which, according to Section 40-6-390 of the Georgia Code, occurs when an individual, quote, "drives any vehicle in reckless disregard for the safety of persons or property." In the 2003 case of Frazier v. State, the Court of Appeals of Georgia concluded that, quote, "Speeding, unaccompanied by other traffic violations, can form the basis for a reckless driving conviction if the state presents evidence that a defendant was driving at an excessive rate of speed given the posted speed limit and the driving conditions existing at the time." Considering these Georgia case law precedents, a court would almost certainly find that Officer Brown's testimony regarding her visual estimation of Ms. Webb's speed was sufficient evidence to sustain a conviction for speeding and possibly reckless driving. Although a jury could find that her admission that she did not know the exact speed made her testimony less credible. However, it's important to recognize that this standard is specific to Georgia law, and some other states prohibit convictions based solely on visual estimates of speed.
No, but you can use the fact that you were going whatever speed and she went past you. It's on camera, so you're going to have a back speed. You're going to have the fact that you went 90 to catch up to her. You're going to have too fast for conditions. And
Yeah, I mean, that's unacceptable. I told her, I said, you know the roads are wet, correct? You're running late for work and you're going above 80 to get to work. I said, call. So do not do that and put people's lives in jeopardy.
Yeah.
So, my CAD just froze on me, so I'm restarting it right now. What do you think? Or just tickets?
Atlanta answer or Roswell answer?
Hold on. Are you? Okay, hold on. Thank you.
Valid.
Yeah, sorry, she did it. Unavailable. My CAD's not working. Who's that?
A head, R tail.
Okay.
Officer Brown told Webb she'd clocked her going over 80 miles an hour. Webb apologized, said she was late for work. What this case proves is something narrower and, in some ways, more disturbing. that the law can permit an outcome that professional standards, departmental policy, and basic human decency cannot. Every officer in this country takes some version of the law enforcement oath of honor, a pledge that explicitly promotes accountability and the maintenance of high ethical standards, a commitment that sits alongside, not beneath, their oath to the state and federal constitutions. When an officer allows a coin flip to substitute for that judgment, they are not breaking the law, they are breaking the oath. And Chief Rusty Grant's decision to fire both officers suggests the department understood exactly that distinction, that lawful is not the same as defensible, and that the public's trust is not something the Fourth Amendment alone.
Regardless of the result, Officer Brown would have been within her authority to arrest Ms. Webb under both Georgia law and the U.S. Constitution. Under Section 40-6-1 of the Georgia Code, most traffic offenses in the state are criminal misdemeanors, including speeding and reckless driving. And Section 17-4-20 allows officers to arrest individuals for crimes without a warrant if, quote, the offense is committed in such officer's presence. Even if state law did not allow for arrests for these offenses, the Supreme Court has established a blanket rule that if a warrantless arrest for an offense committed in the officer's presence is supported by probable cause, it is constitutionally permissible. In the 2001 case of Atwater versus City of Lago Vista, the Supreme Court held that, quote, if an officer has probable cause to believe that an individual has committed even a very minor criminal offense in his presence, he may, without violating the Fourth Amendment, arrest the offender, despite noting that the incidents of the arrest in question were, quote, merely gratuitous humiliations imposed by a police officer who was, at best, exercising extremely poor judgment. The Supreme Court later affirmed and expanded this decision in the 2008 case of Virginia versus Moore, concluding that, quote, warrantless arrests for crimes committed in the presence of an arresting officer are reasonable under the Constitution, and that while states are free to regulate such arrests however they desire.
A coin decided her freedom. Say that sentence again, slowly, and ask what it would mean if it had happened to you, on a highway, in the rain, with no one else watching. There is one more thread worth pulling before we close, and it's the one the record leaves genuinely open. Officer Brown told Webb she was traveling over 80 miles an hour. Later, in her own words captured on the recording, she admitted she wasn't actually certain how fast Webb had been going. She was estimating, based on how quickly she herself had to accelerate to catch up.
For example, the Georgia Department of Public Safety Policy Manual identifies certain circumstances when traffic offenders can be arrested, and all other custodial traffic arrests are prohibited. The Roswell Police Department Policy and Procedures Manual, on the other hand, does not specifically limit traffic arrests, but it does require that, quote, whenever appropriate, an officer should use alternatives to physical arrest by issuing citations. However, by deciding whether to arrest Ms. Webb based on a coin flip, the officers likely violated another section of the Roswell Manual, which states that, quote, police officers, having a position of trust and civic responsibility, should so conduct themselves as to merit the confidence and respect of the public and fellow officers. The policy also requires that officers, quote, conduct themselves in such a manner as to reflect a favorable image on themselves and the Roswell Police Department. Members will consider it their duty to be of service to the general public, and to render that service in a kind, considerate, and patient manner.
This is tail, right?
Yeah, so really.
23.
Michael Jordan? Hi. So I got too fast for, let me write this down.
Too fast for conditions.
Is it reckless?
Yeah, you can do reckless, and then speeding. And you're just gonna have to mark the pace one instead of the...
I mean, either way, the speed limit here is what, 45?
Yeah.
45. She was going way,
Yeah.
I mean... Because I haven't done one like speeding like that, so that's why I'm a little bit unsure.
You're going to do the patrol vehicle spot, and then it's going to ask you for moving or not moving, and you're going to do moving.
Can you help me do these dang tickets? My CAD won't even log me in. Sorry. Alright, I'm gonna go. Yeah, that's not okay. Yeah.
Under Georgia law, both options were legally available. Section 40-6-1 classifies most traffic offenses, including speeding and reckless driving, as criminal misdemeanors. Section 17-4-2 permits a warrantless arrest for any offense committed in an officer's presence. And under the U.S. Supreme Court's 2001 ruling in Atwater versus City of Lago Vista, An officer with probable cause to believe even a minor offense occurred may arrest the offender without violating the Fourth Amendment, a rule the court reaffirmed and broadened in 2008's Virginia v. Moore. The Atwater court itself acknowledged that the arrest before it involved, in its own words, gratuitous humiliations imposed by a police officer who was, at best, exercising extremely poor judgment. The court upheld it anyway. Constitutional does not mean acceptable. That distinction is the spine of this entire case.
Alright, ma'am. Do me a favor and step out of the vehicle for me. Put the phone down.
Why am I
Put your
doing
phone down. Step out of the vehicle. Turn around, put your hands behind your back. Because, ma'am, you're driving entirely too fast for conditions. You put a lot of people's lives in jeopardy, okay? Double locking these so that they don't tighten on you. Do me a favor and step in front of my vehicle, ma'am. Step in front of my patrol vehicle. Do you have anything in your pockets of? Do you have anything on you that poke, stick, or stab me? Any drugs, paraphernalia, anything like that? Okay. You have a bond. Return to the side for me. Here, move over, Cass. I'm just gonna shake this out, okay? Alright. Do me a favor, step over here. It's my patrol vehicle. Have a seat for me. We're gonna buckle you in, okay? RDR 390R. Alpha 1 in custody.
919.
Alpha 1, can you please start me at 85?
Here, the vehicle contained evidence of a crime without violating the Fourth Amendment. Similarly, in the 1991 case of California versus Acevedo, the Supreme Court concluded that officers can search closed containers inside of vehicles without a warrant if the search is supported by probable cause.
So Officer Brown had discretion. Full, lawful, constitutionally protected discretion to either write a ticket or make an arrest. And according to the audio captured on scene, here is how that discretion was exercised. Officer Wilson pulled out her phone, opened a coin flip app, and said, quote, "Heads or tails?" Heads, Webb gets arrested. Tails, she walks. The coin was flipped off camera. It landed on heads.
Phone with you. Now your makeup bags and all that. Is it okay to leave those in the car? You can make a phone call, but that's all you can do. If you want to call them, you're allowed to call them. But okay. Give me 1 second. I'll let you call them. Okay. Where does he live? Okay, have a good day, sir.
There's no reason that I should be letting go right now.
Okay.
Ms. Webb was arrested and charged with going too fast for conditions and reckless driving, but the charges were later dropped. On July 18, 2018, Roswell Police Chief Rusty Grant denounced the officer's behavior in a video statement posted on Facebook and stated that the department was conducting a, quote, top-down assessment of the department and bringing in an outside consultant to perform an audit. On July 26, 2018, Officer Brown and Officer Wilson were both fired after the internal investigation was completed. Overall, Officer Brown and Officer Wilson get an F for exercising poor discretion by choosing to arrest Ms. Webb instead of citing her for speeding, violating several aspects of departmental policy and general policing standards, and for demonstrating poor character and an overall questionable ethical aptitude. There is no doubt that a majority of Officer Brown's conduct was lawful. However, it could certainly be argued that while Officer Brown's actions didn't necessarily violate the law, there are serious ethical questions to be raised about hinging the decision to arrest someone on the flip of a coin. A large part of police work is making the most reasonable and ethical decision possible within the bounds of an officer's authority. Most officers are required to take the law enforcement oath of honor along with their oaths to the federal and state constitution. The oath of honor explicitly promotes accountability and maintaining high ethical standards, and officers who neglect to consider the ethicality of their decisions are essentially betraying this oath and failing to fulfill half of their job description. Officer Brown and Officer Wilson demonstrated behavior that trivialized the social and financial impact of being arrested and diminished the department's relationship with its community. And I commend the Roswell Police Department for taking the appropriate action to address their officers' misconduct. As for Ms. Webb, I cannot rightfully issue a grade to an individual who had no control over the dynamics or outcome of this interaction at any point. When Officer Brown initially approached Ms. Webb and informed her that she was traveling over 80 miles per hour, it seemed to genuinely shock her, and Officer Brown later admitted that she didn't really know how fast Ms. Webb was going. This brings the entire stop into question, and there is an argument to be made that no verifiable evidence exists to show that this stop was initiated on a lawful basis. Ultimately, all the charges against Ms. Webb were dropped, and although she was visibly upset in the body camera footage, her ability to remain calm and compliant likely contributed to her charges being dismissed. I commend Ms. Webb for carrying
a coin decided her freedom. Let that sit for a moment, because the legal analysis and the moral reality are about to diverge sharply, and that divergence is the entire point of this video. Legally, as we just established, the arrest itself, independent of how the decision was reached, would likely have survived constitutional scrutiny if challenged, because Atwater and Moore give officers extraordinarily wide latitude once probable cause exists. But the Roswell Police Department's own policy manual tells a different story. It requires that, quote, whenever appropriate, an officer should use alternatives to physical arrest by issuing citations. It further states that officers having a position of trust and civic responsibility should so conduct themselves as to merit the confidence and respect of the public and fellow officers, and that members must conduct themselves in such a manner as to reflect a favorable image on themselves and the Roswell Police Department. A coin toss does not merit confidence. A coin toss does not reflect a favorable image. A coin toss is the precise opposite of the professional judgment that policy demands. So ask yourself the question this case forces you to confront. If the coin had landed on tails, would we even know Sarah Webb's name? Would this footage exist at all? Or would it have quietly vanished into a filing cabinet of routine traffic stops? A woman's brief, unrecorded brush with a decision that could have gone the other way with no one ever knowing how close it came. That is the ticking clock. What happened next followed the script of a routine custodial arrest. Webb was removed from her vehicle, handcuffed, searched, and placed in the back of the patrol car. Officer Brown then searched Webb's vehicle. Now, ordinarily, a search like that would need justification beyond a traffic stop. Officers cannot search a car simply because it was pulled over. But there are established exceptions. Consent is one, established since the Supreme Court's 1925 ruling in Carroll v. United States. Probable cause that the vehicle contains evidence of a crime is another. But what the footage actually shows is neither of those. It shows an inventory search, the standard procedure departments follow before towing an impounded vehicle. The Supreme Court addressed this exact scenario in the 1976 case, South Dakota v. Opperman, explaining that these inventory procedures exist to protect the owner's property, shield police from false claims of theft, and protect officers from potential danger. The court called this practice, quote, not unreasonable under the Fourth Amendment. The Roswell Manual itself mandates that officers will inventory and document the contents of every vehicle being impounded. So on this narrow point, the search Officer Brown conducted was very likely lawful. This case was never about one single unconstitutional act. It was about a pattern of decisions, some legal, some not, that collectively should never have led to a woman spending time behind bars over a Georgia rainstorm and a speed she was never actually measured going.
Webb was charged with reckless driving and going too fast for conditions. Both charges were dropped, not reduced, dropped entirely on July 18, 2018. And 8 days after that, Roswell Police Chief Rusty Grant did something departments rarely do voluntarily. He went public. In a recorded statement, Chief Grant denounced his own officer's conduct and announced what he called a top-down assessment of the department, bringing in an outside consultant to conduct a full audit. On July 26, 2018, both Officer Courtney Brown and Officer Christy Wilson were terminated following the internal investigation. A coin decided her freedom, and it cost 2 officers their careers. Let's be precise about what this case does and does not prove, because precision is the only thing standing between accountability journalism and partisan noise. This case does not prove that Sarah Webb wasn't speeding. Officer Brown's visual estimate, under Georgia precedent, could have supported a conviction had it gone to trial. This case does not prove the arrest itself was unconstitutional. Atwater and Moore make clear the Fourth Amendment tolerates enormous discretion in custodial arrests for minor offenses, however unwise those arrests may be. And this case does not prove the vehicle search was illegal. Opperman and the department's own inventory policy likely cover it. That admission is what makes this entire case unusually complicated. If the officer who initiated the stop wasn't confident in the speed she was citing, then the legal foundation for the stop, the very first domino, becomes harder to defend than the case law alone would suggest. Georgia's appellate courts have upheld convictions built on visual estimates before, but those rulings assumed the officer's estimate was offered with some degree of confidence and consistency. An officer who second-guesses her own number after the fact, on the record, is handing a defense attorney the exact kind of doubt that criminal cases are built to expose. So here is where we leave it, because this channel exists to lay out the public record, not to deliver a verdict for you. The full internal affairs file from the Roswell Police Department's 2018 audit, along with the department's policy and procedures manual referenced throughout this video, remains part of the public record and is available through Georgia Open Records requests. Pull it. Read the inventory search policy for yourself. Read the exact language the department used to justify terminating 2 of its own officers. And then answer this in the comments. If the coin had landed on tails, should this story have ended any differently? Or does the mere existence of a coin flip already tell you everything you need to know about how this stop was actually decided? If this kind of forensic breakdown is why you're here, hit like. Share this with someone who still thinks the officer had discretion ends the conversation. Subscribe to Police Misconduct Case and turn on notifications, because we don't just cover the story, we follow the evidence, one document at a time.